Welcome to our continuing educational webinar series. I am Catherine Short, Partnership Marketing Manager for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business. A hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility, and we help manage every aspect of a compliance program, and our training library provides hundreds of modules that are easy to assign and track. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Rachel V. Rose, JD, MBA, a principal with Rachel V. Rose, attorney at law, P.L.L.C, Houston, Texas, with us today. Ms. Rose has a unique background, having worked in many different facets of healthcare, securities, cybersecurity, as well as international law and business throughout her career. Her practice focuses on a variety of cybersecurity, healthcare, and securities law issues related to industry compliance and transactional work, as well as representing plaintiffs in Dodd-Frank False Claims Act whistleblower claims. In addition to being extensively published and a sought-after presenter and quoted expert, Ms. Rose holds an MBA with minors in healthcare and entrepreneurship from Vanderbilt University and a law degree from Stetson University College of Law, where she graduated with various honors, including the National Scribes Award and the William F. Blues Pro Bono Service Award. Ms. Rose is licensed in Texas and is admitted to practice before all state courts, as well as the United States Supreme Court and the District Court for the District of Columbia and all 4 federal court districts in the state of Texas. She is a fellow for the Federal Bar Association, and currently she is the chair of the Federal Bar Association's Government Relations Committee, a board member of the Federal Bar Association's Ketom section, the co-editor of the American Health Lawyers Association's Enterprise Risk Management Handbook for Healthcare Entities, 2nd edition, as well as co-author of the books The ABCs of ACOs and What Are International HIPAA Considerations. She has been named consecutively to the Texas Bar College, the National Women Trial Lawyers Association Top 25, and Houstonia Magazine's Top Lawyers for Healthcare. In 2019, she was also named to the National Trial Lawyers Association's Top 100, as well as First Healthcare Compliance's 2019 Top Presenter. Ms. Rose is also an affiliated member with the Baylor College of Medicine's Center for Medical Ethics and Health Policy, where she teaches bioethics. See www.rvrose.com for additional information. Before we begin, I would like to mention at First Healthcare Compliance, we strive to serve as a trusted resource for compliance professionals, and every month we celebrate their hard work and dedication with our Compliance Super Ninja recognition. Today, our team is turning the spotlight on Super Ninja Wendy Mulkey, Business Development Marketing at Emerald Coast Neurology. Wendy says, I am a lifelong learner. Working at Emerald Coast Neurology has allowed me to continue to grow and learn. I feel like my contributions are making a positive impact for the staff and patients. At the end of the day, I just want to make a difference. I feel like I'm accomplishing that at Emerald Coast. Congratulations, Wendy. Our team is honored to have the privilege of working with you. A copy of the slides is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your PACOM and PMI certificates will be emailed to you following the broadcast. Your PACOM certificate will come directly from PACOM, and your PMI certificate will come from our email. There is no need to request either one. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. So Rachel, a very warm welcome. We are always so happy to have you here. Thank you for being here today.
Catherine, it's always my pleasure to collaborate with you and First Healthcare Compliance, and likewise, thank you for having me as a guest today.
Thank you.
Okay, so today, as Catherine just mentioned, I am speaking on appreciating the content of a business associate agreement. And whether you are a seasoned healthcare professional or a business associate who's been dealing with the healthcare industry for quite some time, or if you're brand new to healthcare, there's something in this presentation for everyone. But no presentation would be complete without a disclaimer. So the information presented is not meant to constitute legal advice. Consult an attorney for advice on a specific situation. Moreover, the information presented is current as of the date of the original recording. And given the dynamic nature of the topic, as well as the healthcare industry, participants are encouraged to check relevant government websites and case law for the most recent information. So today, I'm going to begin with headline highlights, then delve into a limited portion of HIPAA fundamentals, specifically those items that are absolutely relevant to a business associate agreement or a BAA. From there, I'll go into what is a BAA, then two areas associated with that. First, what content is compulsory? And second, what items are optional or items that you may see when reviewing a BAA? The last two items I'll address are potential landmines to sidestep, and then as always, I will end the presentation with tips and a conclusion before taking questions. So let's begin. The two main areas that I want to focus on are specifically ransomware and then one particular HHS OCR settlement. So let's begin with ransomware. In general, the FBI and CISA have noted that there is an increase in sophisticated and impactful ransomware attacks throughout the holidays and weekends in 2020. This should not be a surprise. Moreover, it should not be a surprise that this occurred in 2021 as well. But stemming back to the beginning of the COVID-19 pandemic in March of 2020, an item that caught my attention was the headline that between March and April of 2020, ransomware attacks increased more than 400%. So again, given that we are still in this hybrid of remote working, dealing with protected health information, as well as the increased utilization of telehealth, as an organization, you need to make sure that your remote offices, as I'll call them, meaning individuals who are working from home, have similar safeguards to what you have in a corporate office setting. Another item that I wanted to highlight for everyone is a newer type of ransomware attack, which first appeared on the scene in June of 2021. It's called Hive ransomware. And what's very notable about this particular type of ransomware is that it is quickly becoming the ransomware of choice for cyber criminals when attacking entities in the healthcare sector. So a couple of highlights about Hive. First, it uses multiple mechanisms to compromise business networks. So basically, this type of cyber criminal who's using this particular type of ransomware comes at it from a variety of different angles, utilizing phishing emails with malicious attachments, as well as remote desktop protocols to move laterally once they are on the network. So after the network has been compromised, then the actors exfiltrate the data and encrypt the files on the network. From there, they leave what I call a love letter or a ransom note in each affected directory within a victim system, which provides instructions on how to purchase the decryption software. The ransom note also threatens to leak exfiltrated victim data on the Tor site. These are known as hive leaks. A note that's related to this last bullet point is, as has been seen with other types of ransomware attack, even though a cyber criminal threatens to leak data, oftentimes the data has already been leaked. So that's just something to be very aware of. Now, an OCR settlement, which occurred in 2019, is also very notable for a variety of reasons. First, the settlement amount. The settlement amount was for $3 million, which, if you look at the typical range for HIPAA violations, once you get up into the millions, that's probably in the top 5 or 10% of all recoveries for OCR. Next, failed to have a business associate agreement in place with vendors. My question in today's world is, how does this happen? Including IT support vendors and third-party data center providers. So just as an aside, it is absolutely imperative that you make sure that you have a BAA in place if you are a covered entity working with an IT vendor, or if you're a business associate and you're utilizing an IT vendor as a subcontractor. Please make sure that you have business associate agreements in place within that link of trust. The same goes for cloud service providers such as AWS or Microsoft Azure as 2 examples. And lastly, third-party data centers. Typically, entities that need a BAA with a data center are your tech companies who have their cloud and servers stored in a data center. And as recent as 2013, I was doing a cybersecurity audit, and I had to laugh because this one data center said, well, we're not a business associate. In fact, data centers are, as are cloud computers or cloud computing providers. And the reason that is the case is that A, they do not fall under what's known as the conduit exception, which is expressly stated in the 2013 final omnibus rule. So because they don't fit into that conduit exception, the law does in fact apply to them. So even if they are not necessarily dealing with the confidentiality or integrity of the data, indirectly they are, because if a data center goes down, and I've had a client where their data center went down and the backup generator didn't kick in, that can really wreak havoc across not only an end provider, but also the IT company as well. So that's why cloud computing and data centers require a business associate agreement. Another aspect of this particular settlement was that the entity failed to conduct an accurate and thorough risk analysis. For those of you who have listened to my other presentations or read my articles, I'm going to reemphasize what the former OCR director Severino indicated in a February 2020 article in Law 360, where he was quoted. OCR looks for low-hanging fruit, and not having a risk analysis done on an annual basis, it is not only considered low-hanging fruit, but an organization is really missing out on identifying gaps or vulnerabilities to their data. So that's why this is so important. It's really the first step in giving a thorough look into how the technical, administrative, and physical safeguards are situated. This settlement also indicated that often overlooked administrative safeguard security incident procedure was not in place, and it served as a reminder that covered entities and business associates, as well as subcontractors, need to implement policies and procedures to address security incidents. Two policies and procedures where this comes into play would be your business continuity plan and your disaster recovery plan. My clients have separate ransomware policies and procedures as well, just because that is a different animal in and of itself. So that's just something to be aware of. 3 ransomware attacks which occurred in 2021 were first, again, highlighting this notion that holidays and weekends are critical times for companies to keep their guard up. In May of 2021, over Mother's Day weekend, cyber criminals deployed DarkSide ransomware against the IT network of a US-based critical infrastructure entity in the energy sector. And this led to a week-long suspension of services. So after access was gained, ransomware was deployed, the data was encrypted, and then as a second form of extortion, the data was exfiltrated before threatening to publish it to further pressure victims into paying the ransomware demand. In May of 2021, over the Memorial Day weekend, a critical infrastructure entity in the food and agriculture sector suffered a Revel ransomware attack affecting US and Australian meat production facilities, which resulted in complete production stoppage. Then we also had a critical infrastructure entity in the IT sector over the 4th of July weekend also fall victim to the Revel ransomware type of attack. You may be familiar with the SolarWinds attack, the Colonial Pipeline attack. Those are very relatable and really correlate to some of the items in here. The next item is very important because these are tips from the FBI. So the FBI's Internet Crime Compliance Center, it's called IC3, provides the public with a trustworthy source for reporting information on cyber incidents. And for my clients who have contacted me about a ransomware attack, I always tell them to make sure that they report it to the FBI first, even before we go through the subsequent steps. I will say that this happens when we know unequivocally that it is a ransomware attack. So basically, they have received over 791,000 complaints for all types of internet crime, which is a record number in 2020. Whenever they publish additional data sometime in 2022, I think we'll see that 2021 will be an even bigger banner year. The reported loss to the entities that reported was over 4.1 billion. Unfortunately, this represents a 69% increase in the total complaints from 2019, and the number of ransomware incidents also continues to rise. So some common types of ransomware that are used, we've already seen Revel, and I discussed Hive. We then have Conti, PYSA, Lockbit, Ransom, EXX, Zeppelin, Crisis, Phobos, etc. So now let's move into some HIPAA fundamentals and some items in particular that are relevant to business associate agreements. Let's begin with the general definition section. For those of you who are new to HIPAA, 45 CFR 160.103 is the section of the CFR related to definitions. So it's important to appreciate how a business associate is defined. So with respect to a covered entity, it is a person who, on behalf of such covered entity or of an organized healthcare arrangement as defined in this section, in which the covered entity participates, but other than in the capacity of a member of the workforce of such covered entity or arrangement, creates, receives, maintains, or transmits. And I'm going to press pause right here. Whenever I write business associate agreements, or I write policies and procedures, or if I am advising clients on other related types of documents, you will always see the language creates, receives, maintains, or transmits PHI. That's how you know that a relationship exists between a covered entity and a business associate, or a business associate and its subcontractor. So basically, that's pretty much what that is. The types of function or activities include claims processing or administration, billing, data analysis, processing or administration, utilization review, things of that nature. Or a business associate provides, other than in a capacity as a workforce member of the covered entity, legal, actuarial, accounting, consulting, data aggregation, management, administrative accreditation, or financial services. This is key, the financial services, because if there is a situation where a merger or an acquisition is being contemplated, an asset purchase agreement will be in play, and there may even be a letter of intent. Typically, during a healthcare transaction, if an acquisition or a merger is being contemplated, a good due diligence, and really adequate due diligence, requires the other entity, whether it's a private equity firm or a bank or another third party who is looking to acquire another entity. It basically requires that that business associate agreement is in place, because any good and thorough due diligence requires a deep dive into financials, certain claims data, and sometimes the claims themselves. So those are all things that you need to be conscientious of. Legal, it depends on the type of services that are being rendered. I have some clients where I have a BAA because I'm actually seeing protected health information, but I have other clients where I don't ever go in and look at protected health information. Then I have a third category where I didn't start out looking at PHI, but eventually an issue arose and they asked me to assist with that. So at that point, we initiated the business associate agreement. So it's in place, it just depends, and you have to look at the facts and circumstances. Another key item is that a covered entity may be a business associate of another covered entity. Again, that's fact and circumstance specific, because as those of you who work, for example, for a provider know, you don't execute a business associate agreement with every Walgreens or every pharmacy that your patients go to. And that's because in that situation, that's part of treatment whenever you send a prescription over. So that's, again, just something to be aware of. Now, a business associate includes the following: health information organization, e-prescribing gateway, or other person that provides data transmission services with respect to PHI to a covered entity and that requires access on a routine basis to such PHI. A person that offers a personal health record to one or more individuals on behalf of a covered entity, or a subcontractor that creates, receives, maintains, or transmits protected health information on behalf of the business associate. So if you think about it, the definition of a subcontractor is contained within the definition of a business associate, but when you think about it logically and practically, the linear link is covered entity in privity of contract or creating, receiving, maintaining, or transmitting protected health information with the business associate. And then the business associate then creating, receiving, maintaining, and or being in privity of contract with the subcontractor. So that's really how one should think of that. It's also important to appreciate what a business associate does not include. So first, a healthcare provider with respect to disclosures by a covered entity to the healthcare provider concerning a treatment of that individual. A plan sponsor with respect to disclosures by a group health plan or health insurance issuer with respect to a group health plan to the plan sponsor to the extent that the requirements of another subchapter are met and apply. A government agency with respect to determining eligibility for or enrollment in a government health plan that provides public benefits and is administered by another government agency, or collecting protected health information for such purposes to the extent such activities are authorized by law. Now, a covered entity participating in an organized healthcare arrangement that performs a function or activity as described by paragraph 1.1 of this definition for or on behalf of such organized healthcare arrangement, or that provides a service as described in paragraph 1.2 of this definition to or for such organized healthcare arrangement by virtue of such activities or service. So again, these are fact and circumstance specific, but it's important to note that these do not qualify as being a business associate. So who falls under the legal umbrella? Well, first and foremost, covered entities, which fall into three main buckets: healthcare providers, health plans, and healthcare claims clearinghouses. It's important to note that there's a multitude of types of providers, including hospitals, physicians' offices, pharmacies, physical therapy centers, etc. Business associates are either in privity of contract with covered entities, which is that linear relationship that I just described, or they create, receive, maintain, or transmit protected health information. Again, subcontractors are the entities that a business associate contracts or creates, receives, maintains, or transmits protected health information to. It's important to delineate the federal definitions from certain state definitions because they're not all the same. And in Texas, we have Texas House Bill 300. This was then codified in statute in the Texas Health and Safety Code and the Texas Business and Commerce Code. It's been around since September 1st of 2012. Now, the definition of a covered entity is the only definition that appears in the Texas law. So it's broader than the federal HIPAA definition and includes not only business associates, covered entities, and subcontractors, but encompasses anyone who creates, receives, maintains, or transmits protected health information. The Federal Trade Commission is important because it fills the gap of federal HIPAA definitions. Again, there are two prongs to the Federal Trade Commission. There is the Federal Trade Commission's breach notification rule, which has been around for over a decade. And then there is the notification provision as well. So even if you don't fall under the federal HIPAA definitions, you still may have to notify your consumers or patients that there has been a breach of protected health information under the Federal Trade Commission laws. Having said that, the Federal Trade Commission also has jurisdiction to assess penalties for anyone, those entities under federal HIPAA or just anyone in general. And specifically, we've seen it in the past since about 2009 with Rite Aid, CVS, and more recently, Henry Sheen Dental. What is a hybrid covered entity? Well, hybrid entity means a single legal entity. So if you have an LLC or an S Corp or a C Corp, that has to be your covered entity. The business activity is what is the focus here. It would include both covered and non-covered functions, and it designates healthcare components in accordance with paragraph 45 CFR 164.105. What about the legislative history? Well, first and foremost, it's HIPAA's 25th anniversary on August of 2021. So we are just past the actual date for HIPAA's 25th birthday. And if you have not had a chance to listen to our program on First Healthcare compliance related to that, I'd recommend that. It was a lot of fun and we had a lot of great questions. But again, HIPAA goes back to 1996. From there, we see the privacy rule, and I call this the final privacy rule, which was published in the Federal Register on August 14th of 2002. The initial privacy rule was published in December of 2000 and became effective January of 2001. So then we bop ahead to 2003, and this is when the security rule is published in the Federal Register on February 20th of 2003. Importantly, the security rule did not become effective until 2005. A couple of key differences between the privacy rule and the security rule are that the privacy rule includes all forms of protected health information, while the security rule only applies to electronic protected health information. So the requirement to do an annual risk analysis, that falls under the security rule. The requirement to provide patients with a notice of privacy practices, a HIPAA authorization, and to give them their protected health information via a medical record that they asked for within 30 days at a typical maximum. However, a 30-day extension can be given in certain circumstances. So that's the difference between the privacy rule and the security rule. And it's important to note that HHS OCR can and does enforce violations of both. So now we fast forward to 2009 and we see the passage of the HITECH Act. And the HITECH Act was critical for a lot of different reasons, including the program formerly known as Meaningful Use and the more express recognition that business associates may be liable for HIPAA violations and breach notification. Later in 2009, we see the breach notification rule, and the key takeaways here are HIPAA does have both civil and criminal penalties potentially associated with it. There are 4 tiers of penalties, and the key distinction, aside from the amounts that would need to be paid, is that you have to look at the scienter, or the knowledge requirement, and the intent that an individual had or a person had in the event of a breach. So you have to look at the mental state, the mind, and that's when it goes from not knowing but should have known, you get into reckless disregard, deliberate disregard, and then knowingly and intentionally. From there, we go to 2010, and that's when the privacy and security interim proposed rules or proposed regulations came into being and were published in the Federal Register on February 17th of 2010. The final omnibus rule is really the grandmother of them all. It's almost like the Rose Bowl. And what you want to look at there is 78 Federal Register 5566. The omnibus rule has particular significance because it left no doubt in anyone's mind that business associates and subcontractors could be held equally as liable as a covered entity for a HIPAA violation, typically a breach. So the omnibus rule, again, very important to read. Now, in 2016, the 21st Century Cures Act passed. And this law is very important because in May of 2020, we saw two final rules issued in relation to this law. One came out of ONC, the other one came out of CMS. And for those of you who are not familiar with information blocking, you really need to be, because it has to do not only with the security rule from the standpoint of keeping data secure, but really more importantly, the privacy rule and the ability for patients to have a different type of access to their medical records, as well as the ability to receive their records in ways that entities were not required to do before. So again, that's one not to overlook, and First Healthcare Compliance and I have collaborated on a couple of separate webinars and publications related to that. Now, this is exceptionally important. It's HR 7898, and it was signed into law on January 5th of 2021. It addresses the recognition of security practices and amends the Health Information Technology for Economic and Clinical Health Act by adding section 13412. It also added a technical correction to the Public Health Service Act, and throughout the pandemic, the PHSA has been mentioned quite a bit because it's relevant to a lot of the emergency measures that were permissible during the pandemic. So what are the key items here? First and foremost, there's no liability for non-participation. However, if you use recognized security practices and you are able, as a covered entity, business associate, or subcontractor, to adequately demonstrate that you've had in place for not less than the previous 12 months recognized security practices that may mitigate fines, result in an early audit termination, and mitigate remedies. So basically what this does is, for those of you who have undergone a comprehensive risk analysis, your auditor should have crosswalked the HIPAA security rule, CFR standards to NIST. And I've been doing that for over a decade now. This is what gives those reasonable assurances. So it's exceptionally important to make sure that that crosswalk is being used, that NIST is being incorporated into training, and that it's referenced in your policies and procedures. Again, an ounce of prevention is worth a pound of cure, and it's something not to overlook in terms of doing that annual risk analysis and having it crosswalked with NIST. So what is a business associate agreement? A business associate agreement is fundamentally a binding contract. And I think that's something that is very, very important to appreciate. And that's why in the three buckets in my practice with some of my clients, there are clients that I know I'm viewing PHI for, and because of that, I sign a business associate agreement with that entity. If I'm giving advice that's outside of that, I'm simply reviewing contracts and I don't need to sign a business associate agreement. The last scenario is when number two really transfers into a scenario where I then need to read either financial protected health information or actually claims and charts. So at that point, that's when we sign it. It's just, if you know right off the bat that you're creating, receiving, maintaining, or transmitted protected health information, you have got to enter into a business associate agreement. So what are the three primary purposes of the BAA? Well, first, for those of you who are familiar with it, it's to provide assurances that both parties are adhering to the privacy rule and the security rules requirements. Additionally, the party should address the steps of a reportable event. And I would recommend in your training and in your policies and procedures, you need to have two distinct categories. You need a potential cyber event, for example, or a potential cyber attack. And then you have a reportable event or a reportable breach. And that's important because if someone says in an email, we've had a breach, it might not actually be a breach once the 4-step root cause is done in terms of having to report it. So that's why you need to ascertain any potential event. Of course, you want to go through the steps and report that potential cyber event to a manager in your internal processes. However, calling it a breach is in another category. Once it's definitively a breach, which ransomware attacks are, then you absolutely have to report it in accordance with the breach notification rule, which includes notifying the other party within a specified time frame. So all of that is exceptionally important. And lastly, setting forth how the data will be returned or disposed of when the relationship between the parties ends, and addressing other circumstances such as a legal hold or government investigation, which may preclude the information from being returned or destroyed at that point in time. So again, one item or one area where the inability may arise is if there is an audit going on, a government inquiry, or a legal hold has been in place. Then what you do is you just work it out between the parties, but it needs to be set forth in the BAA up front. So 45 CFR section 160.504, I mentioned previously, it's in one of the definitions. And what does it mean to have a business associate contract? Well, most people call them business associate agreements, but you can call them data privacy and security agreements. Really, the title is not dictated by the law. As long as you have a contract that has the compulsory items in it, you're going to be okay. So basically, a covered entity is not in compliance with certain standards if the covered entity knew of a pattern of activity or practice of the business associate that constituted a material breach or violation of the business associate's obligation under the contract or other arrangement. Unless the covered entity took reasonable steps to cure the breach or end the violation as applicable, and if such steps were unsuccessful, terminated the contract or arrangement if feasible. Likewise, a business associate is not in compliance if the business associate knew of a pattern of activity or practice of a subcontractor that constituted a material breach or violation of the subcontractor's obligation under the contract or other arrangement, unless the business associate took reasonable steps to cure the breach or end the violation as applicable, and if the steps were unsuccessful, terminated the contract or arrangement. So again, this is why this is so important, and that's why those reasonable assurances are required up front. HIPAA generally requires that covered entities and business associates enter into agreements with their business associates to ensure that the data is properly safeguarded. And again, basically, the language I use is that the parties agree that the technical, administrative, and physical safeguard requirements of the security rule are implemented. So HIPAA omnibus rule, I mentioned this as being critical for a lot of different reasons. One of those reasons is it modified business associate agreement requirements. It required entities to execute a BAA that includes the modified provisions, and the compliance date was back in September of 2013. So if you haven't revised your BAA yet, you're already out of compliance, and God forbid there's an OCR audit, they will hone in on that. So it's always good to have your external HIPAA counsel or your auditor really take a look at that. What I do in my contracts is a couple of different things. First, we always address state laws, especially one like HIPAA, which may have, or like Texas, which may have a different definition for covered entity, for example. Another one is related to, these days, not only information blocking, but the requirements under the 21st Century Cures Act to get those patients that data. So that could be a specific change within a particular relationship and that particular contract. If a business associate is required and contracted to get patients their protected health information, but that's something you need to consider too. Another consideration is if you know you're contracting with a covered entity that is a substance abuse and mental health facility, as that is defined in 42 CFR Part 2, you really want to make sure that you have the requirements of SAMHSA Part 2 in your business associate agreement as well. So let's take a look at compulsory content. Again, we're going to go to our favorite section, 45 CFR 160.504E2. Implementation specifications. Basically, these contracts, the BAA, must do the following: establish the permitted and required uses and disclosures of PHI, including a provision that the contract may not authorize the business associate to use or further disclose the information in a manner that would violate the requirements of this subpart, if done by the covered entity, with a couple of exceptions. The contract may permit the business associate agreement to use it to carry out its duties. And then second, it may permit the business associate to provide data aggregation services. A note on B there is that if the business associate is taking that information and in turn selling that information without the express written consent of the patient, that's when you can get into criminal trouble. And we've seen that recently in a variety of indictments, one coming out of the Northern District of Georgia that involves Gwinnett Medical Center, and another one out of the Eastern District of Texas. So the business associate will do the following. Well, they won't use it for any unlawful purpose, and they won't use it for any other purpose other than what they're supposed to be doing per what they're engaged to do. Use appropriate safeguards. And again, that goes to the technical, administrative, and physical safeguards in order to ensure that the confidentiality, integrity, and availability of the information remains intact. report to the covered entity any use or disclosure not provided for by the contract, including breaches. And actually, I always put a mutual requirement that the covered entity, if they have a ransomware attack or a breach, also has to tell the business associate. Because if the business associate, for example, is doing claims processing or they're doing collections for a health entity, what if something happens and they need to protect their own infrastructure? There's a lot in play there, and it's something to be aware of. So in accordance, ensure that subcontractors also act accordingly, make available PHI in accordance with 164.524. That's the privacy rule, and this is where I also, depending on the role of the entities that I'm dealing with, we have begun referencing the 21st Century Cures Act too, because when you read the ONC final rule in particular, you see this convergence of the HIPAA privacy rule, the security rule, the High Tech Act, and the 21st Century Cures Act all in one. So it's kind of a fun bundle to deal with. And then make sure that any amendments are available and done in accordance with 164.526, and the amendments relate specifically to the health record of the patient. Another item here, again, our favorite section, it keeps going all the way through J. You want to make the information available and provide an accounting of disclosures. You want to make sure that it's meeting the requirements and obligations that the covered entity has. This one here is very important, so I want everyone to listen and read this as I'm going through it, because this is a landmine area, and landmines that really blow my mind sometimes. Make its internal practices, books, and records relating to the use and disclosure of protected health information received from or created or received by the business associate on behalf of the covered entity, available to the secretary for purposes of determining the covered entity's compliance with this subpart. Nowhere in the CFR does it say that the contracting party needs to provide that information, which basically constitutes trade secrets, to the other party. And that's an area that is really disconcerting for me when I see that. And sometimes what entities ask for is really quite egregious. At termination of the contract, if feasible, return or destroy all protected health information received from or created or received by the business associate on behalf of. So again, this goes to one of our top 3 purposes behind a BAA. You want to extend the protections of the contract to the information and limit further uses and disclosures to those purposes that make the return or destruction of the information infeasible. Finally, in this separate subsection, you want to authorize termination of the contract if there is a material term violation. So again, typically that would relate to not having the technical, physical, and administrative safeguards in place or experiencing a breach. So what does HHS say? For those of you who grew up on Family Feud and watched Richard Dawson, survey says HHS on its website posted what I call the top 10 areas to consider in your business associate agreement. Establish those permitted and required uses and disclosures. Provide that the business associate will not use it for any nefarious purposes or disclose the information. Sale and marketing do fall under that. Marketing has a different definition under HIPAA, so that's just something to be conscious of. Require the business associate to implement those technical, administrative, and physical safeguards. Again, I always make sure that that's mutual, because in today's day and age with telehealth, especially the increase in teleworking, as well as the manners and methods that cyber criminals are attacking, it's incumbent upon both parties to protect that data equally. The onus should not fall all on the business associate. The covered entity has to meet those same obligations. Require the business associate to report to the covered entity any use or disclosure not provided for in its contract, and that does include breaches of unsecured protected health information. Require the business associate to disclose PHI as specified in its contract to meet the covered entity's obligations. Carry out the covered entity's obligation under the privacy rule. And again, this is where you really want to consider adding the 21st Century Cures Act final rule language from ONC where appropriate. Require the business associate to make available to HHS its internal practices. Again, this is only to HHS. It's not to the world. And in fact, I'd say you really need to consider why you would just hand over the keys to your business, your books, your records, your internal practices, everything. That's not permissible. And anyone who asks for that is pretty bold. Now, having said that, I have seen extensive line-by-line checklists that are required to be completed, and rightly so. If an entity is engaging with a business associate to do a clinical trial, they really want to have a line-by-line assurance that all of the security rule items are in place. So just as in life or on any type of attestation, do not misstate that you're compliant when you're not. But again, you should also keep two sets of policies and procedures, one with what I call the keys to the kingdom, and another one that's more general that you could give to show that in good faith your general, workforce policies and procedures. You can also have an entity review them so that they don't have a copy of them. Again, if this is routine, I wouldn't recommend that, but there are situations given the sensitivity or the heightened sensitivity of the protected health information that it should really be approached even with more safeguards to it. Termination of the contract, again, you want to return or destroy appropriately in accordance with NIST. Having said that, if a legal hold or a litigation or a government investigation is ongoing, then that's something that would need to be disclosed, and you would be required to keep that information as long as necessary so that spoliation does not occur. Require the business associate to ensure that any subcontractors it may engage on its behalf that will have access to protected health information agree to the same restrictions and conditions that apply to the business associate with respect to such information, and authorize the termination of the contract. So what are some other items that I see in business associate agreements? These are what I call the may items. So first, let's begin with our favorite section and go to subsections 4 and 5. Other requirements and other arrangements. The contract or other arrangement between the covered entity and the business associate may permit the business associate to use the PHI in its capacity as a business associate to the covered entity if necessary, again, for the proper management and administration or to carry out the legal responsibilities. Jumping down to number 5, business associate contracts with subcontractors. 3 or 2.5 lines basically to sum up. If you're a business associate creating, receiving, maintaining, or transmitting protected health information with a subcontractor, you need a BAA in place. These are some other items that I often see and that I incorporate into business associate agreements. Because it's a contract, you want to make sure you have your choice of law, venue, and jurisdiction. Moreover, you want to make sure that it is consistent with what your other contracts are using, because typically a BAA would be referenced in the main contract, or it's an appendix, but it is still a binding contract. And you don't want to be all over the country, or in some cases, as I've seen, all over the world, to deal with the similar contracts which go to the same transaction. Reference to the MSA or other engagement contract, I've seen that done, and something that is disconcerting is that sometimes I see contradicting terms. Another thing that I'll see is that a breach of the business associate agreement can lead to the MSA being terminated and non-payment occurring. So again, you need to make sure that you're reading both in pari materia with each other. Indemnification is very significant, and it somewhat varies depending on the jurisdiction you may be in, as some states rely on statutory provisions related to indemnification and others rely on common law, but there are a lot of different ways to use indemnification, but it always gives me heartburn when I see it very one-sided instead of being more mutual. State laws, absolutely relevant to include, and the party responsible for notifying HHS and patients, and in cases where there's a breach of over 500 people in a single incident, you also have to notify the media. But why is this interesting? Because per the regulations, the covered entity is responsible, unless it is designated that, for example, the breaching party has to notify HHS, and it's done so in the BAA. So I've dealt with this before when representing entities in front of HHS, OCR, and really the best practice is for the business associate to uphold their obligation and alert HHS, but also when they alert the covered entity, tell the covered entity to just send a letter to HHS indicating that business associate or subcontractor notified them that a reportable breach occurred and that they had notified HHS on X date. This is just a follow-up to ensure that HHS knows that the covered entity is aware. So what are some landmines to avoid? Well, first, look for differences in the contracts between venue, choice of law, and/or jurisdiction provisions. Indemnification language, again, you want to look at your MSA and your BAA to see how indemnification language is lining up. And really, do you really want to indemnify the other party while having no protections for yourself? That's why I've always been a fan of a more mutual indemnification. Paying ransom in the event of a ransomware attack, yeah, don't do it. And I've seen a couple of very disconcerting provisions in business associate agreements or MSAs lately related to this. This is particularly problematic for three reasons. One, the FBI, CISA, and DHS say not to. And if you recall from the beginning of the presentation, we have the IC3 portal that the FBI has to report ransomware attacks and cyber breaches. Second, the Office of Foreign Asset Control issued a bulletin in October of 2020 reminding people that paying certain bad actors may result in criminal liability. So if you're paying ransomware, even if you don't know who the cyber criminal is or who an end state actor is, if it comes out that you paid money to what I call an entity on the do not disturb list, it's problematic. And why would anyone agree to this when it could constitute providing legal advice? That's something that I've never understood, and I just reviewed and revised a business associate agreement that said the other entity should pay the ransom, and it blew my mind. But those are the things that you really need to be looking out for. The provision that books and records are open to the contracting party? No, as I've highlighted twice, the law only requires these items be made available to the secretary. And the types of reasonable assurances that are being requested, again, some people overstep in a way that puts the other person party to the BAA at significant risk, or their trade secrets or other sensitive information at risk. And as we get into the tips and conclusion, I will highlight 5 items that you can put on an attestation which show that you are in good faith getting reasonable assurances from these people. I, as a lawyer, have written letters for my clients, and we have not received any pushback from any entity that indicates that they have all of these things in place, that everything is comprehensive, that they are in accordance with the law. But here, cybersecurity enforcement is only becoming more of a focus for government agencies. Ransomware attacks are on the rise, so it is incumbent upon all parties to do their part. Be on the lookout to make sure that BAAs have the basics covered. That is what is expressly stated in the law, as well as sidestepping those landmines and provisions that can lead to legal trouble. Compliance is key, and again, these are the 5 items I always recommend getting a signature on. Has an annual risk analysis been done? Are BAAs in place with all covered entities, business associates, and subcontractors? Are policies and procedures adequate and reviewed at least annually? Are workforce members undergoing annual training? And is the PHI and sensitive PII encrypted both at rest and in transit? And with that, Catherine, I wanted to hand the floor back over to you so that I can take any questions.
Okay, thank you so much. We do have a few questions, and that was a really wonderful presentation concerning the BAAs. The first question was, could you please repeat the 5 items you mentioned to obtain reasonable assurances?
Absolutely. And I'm just going to take it a step back here to these 5 items on the last bullet point. First, has a comprehensive annual risk analysis, preferably with that crosswalk to NIST, been done? Second, are BAAs in place with all the required entities? Third, are policies and procedures adequate and reviewed at least annually? Fourth, are workforce members undergoing comprehensive annual training? And lastly, is PHI and sensitive PII encrypted both at rest and in transit?
Okay, great. Okay, here's a good question. Well, everyone always has great questions, but what about if an entity doesn't fit into one of the federal HIPAA sections or buckets of covered entities or business associates or subcontractors? Is there still potential liability?
Yes, and that goes back to the 2 areas that I mentioned on our who is covered under the umbrella of HIPAA slide. So first we have state law, and there's always a potential for violations such as in Texas to occur, because our definition in Texas is much broader than the federal definition of covered entity, business associate, and subcontractor. The second way is through the Federal Trade Commission. So those are really the 2 ways that liability can apply that's outside of HIPAA.
Okay, and then I think we have time for one more question. I know, attorneys, of course, like to parse words, and so do a lot of the rest of us. So it's called a business associate agreement. So is it a binding contract?
It is a binding contract, and that's what we saw in our favorite section, 45 CFR 160.504. That absolutely is spelled out there that it is a contract.
Okay, great. Thank you for clarifying that. Okay, do you have any other words of advice that you would like to leave with us today? I know it's a really large subject, so I know there's so many things that we could continue talking about. But do you have any other words of wisdom?
I would say the final words of wisdom are really to have a knowledgeable healthcare lawyer review your BAA so that you know what to look for. The language oftentimes will be very similar, but it doesn't necessarily have to be identical. I've read several BAAs that really just had what HHS proposed that met the requirements in the law, but didn't have much of anything else in it. I've seen others that were more thoughtful in terms of really going through and thinking about the language and where they wanted it to go, and then adding provisions like indemnification, the jurisdiction, severability, things of that nature. And then the last part is really, I think this presentation should be the first step in really trying to appreciate the contractual language and not jumping down someone's throat, whether it's another entity you're contracting with or a lawyer. And I think by understanding what's required and then where there's latitude, that can make a big difference in having a really reasonable discussion with someone.
Okay, all right. Well, thank you so much, Rachel. Very, very much appreciate it. So thank you.
Very, very much welcome. And as always, I truly enjoyed being here with you today in First Healthcare Compliance.
Thank you. We really appreciate it too. And I wanted to remind our attendees that on our website and also on our YouTube channel, but both, you can find other webinars that we've done with Rachel Rose on such a great variety of subjects. And then also on our website, we have blogs, articles, and also podcasts, radio shows. So please check those out because it's a wealth of information. Please use the contact information on the screen for any questions, any further questions that you have for Rachel Rose. And if you think of any further, send us questions. We'll forward them on to her. Please remember your PACOM and PMI CEU certificate will be emailed to you from within 2 days following the broadcast today. There's no need to request it. You can register for future webinars or request a demo of our compliance solution on our website, firsthcc.com, or call us at 888-543-4778. And thank you for joining us.